Welcome back, everybody. Aaron Keller here on the Law and Crime Network. The judge is taking an afternoon break right now after collecting a thick stack of cards containing questions from members of the jury. He told the jurors, hey, look, let's take our break. We will review those questions for any potential objections while you are on your break, and we'll ask them of the witness when we come back. That's an efficient use of time. This judge has been very, very timely in this case. So, while we get ready for our discussion on this testimony from the sleep expert who's been on the stand and our discussion of counts 6 and 7 of this indictment being dismissed, while we prepare for that, let's get caught up to speed on a critical witness from yesterday. This was the spokesperson whose testimony ultimately played into the dismissal of one of the charges today.
Former spokesperson and critical witness Jeff Dickerson took the stand in the murder trial of prominent Atlanta attorney Claude Tex McIver. McIver stands accused in the shooting death of his wife Diane. The prosecution believes the defendant had financial motives for the killing and went to great lengths to have the charges drop and hinder the investigation. Dickerson took the stand and testified that McIver hired him to manage and interact with journalists. Dickerson knew the district attorney of Fulton County, Paul Howard, and offered to reach out to him. McIver said he would offer a bonus if he could make that happen.
That it would be okay with him, I think were his words, if I shared that with others. And I asked for clarification because I thought that he might have some other communications team or others working on this project. And in seeking that clarification, it became clear to me that he was making reference to the district attorney.
Dickerson claims he attempted to contact Howard to eliminate or reduce the charges. But once he told Howard who his client was, Howard stopped responding.
How did you attempt to contact Mr. Howard?
By text message.
And can you tell the jury, what did you say to him?
I'd like to talk to you about a new client.
Did he respond to your text message?
Yes.
Okay. And what did you say back to him after he responded to your text message about wanting to talk to you about a new client?
I told him who my new client was.
And can you tell the jurors, did you receive a response from Mr. Howard once you said to him that your new client was Tex McIver?
I received no response at all.
Howard's silence was a clear indication that the request was inappropriate, but McIver apparently didn't care.
Can you tell the jury, did you communicate that to the defendant?
Yes.
What did you say to him?
He hasn't responded. He's not responding, and I think that that's instructive. I think that says a lot.
What was his response?
Disappointment. Try again.
On cross-examination, Dickerson admitted McIver never directly asked him to bribe Howard.
Mr. McIver never said to you, tell Paul Howard if the charges are dropped, there'll be money in it for him. Did it?
No.
For Law and Crime, I'm Rachel Stock.
Okay, that was some of the testimony from one of the spokespeople who testified yesterday for Tex McIver. I want to bring Gary Gerstenfeld into the conversation. He's an attorney, and he joins us here regularly here on Law and Crime. Gary, good to see you today.
Good to see you, Aaron.
Okay, so we had a lot of moving parts in this case today. We had 2 of the counts dismissed. One of those 2 pertained to the husband of the driver of the car when the gun went off. The other pertained to one of the spokespeople. The spokesperson to whom the dismissed count pertained was Bill Crane. He had testified that Tex McIver asked him to walk back a statement that McIver had indeed made before. And the state was trying to say that that was witness tampering because the statement that that particular witness had put forth in newspapers and publications and whatnot could have been aimed at prosecutors and police officers and detectives. And the judge is like, that's not the purpose of the statute for witness intimidation, witness tampering in the state of Georgia. Trying to ask someone to walk a statement back that's been made in the newspaper is not tampering with a witness. It's asking someone to retract a statement. Does it ultimately look good for McIver? Well, no. And the judge says to the prosecutor, you can still use this evidence as consciousness of guilt for the other charges that are still on the books. Do you agree with this characterization? What do you think?
Absolutely. The biggest thing and the difference between the two counts that were dismissed, which was the spokesperson, as you pointed out, and the husband of the hairdresser, Diane, the hairdresser. The biggest difference is these guys were not actual fact witnesses to the case. Fact witnesses to the case are, I saw something, I have something to report, and it moves the case forward. And that would be the hairdresser, the lady that was driving the vehicle. She is a witness to the case. She was in the car when the shooting occurred. That witness tampering count survives, and that makes sense because she's actually involved in the case. And what Texas is trying to do, according to the state at least, is get her to change her testimony. So that clearly would rise to the level of tampering with witness intimidation or whatever the theory is. But that's a direct effect on the outcome of the case. Whereas these other witnesses, they're ancillary. They weren't in the car. They're not direct witnesses on the case. They don't play a pivotal role.
Well, you know, Danny Jo Carter's husband was apparently asked by McIver through a voicemail to tell his wife not to talk to the police. That's the other charge. The judge said that was stretching it a little bit too thin as well. Now, to me, I wasn't so sure about that one because, okay, well, ultimately McIver's telling Danny Jo Carter to clam up. But then I thought about it for a second. I said, well, clamming up is not the same as lying. So is that the line that the judge drew on that one as well?
Well, again, the prosecution has their theory and looks at things through their optics, which is, you know, anytime a defendant talks to a witness in a case, gee, that could be witness tampering. And so that's ultimately a decision I think the jury's going to have to reach. But because her role, Danny's role is that she's directly involved in the case. She's a direct witness in the case. She was in the car when the shooting occurred. So her testimony is critical either for the defense or the prosecution, but that's a critical witness. Anytime that a defendant talks to a witness who has direct information about a case, that raises the possibility of the argument of witness tampering. Very different than the situation with these other two witnesses.
So, look, the judge at the end of the day said, I'm going to wipe these charges off the table, but you still have a witness tampering charge, or its analogous language in Georgia, on the table related to Danny Jo Carter. You still have all the other charges. You've got the murder, you've got the felony murder, you've got the weapon charge, you've got all this other stuff that they've thrown at Tex McIver over the course of this case. So, you know, it seems that the judge is saying, okay, and the judge did say, look, I don't like that he made this call. I don't like that he asked the publicist to walk back the one statement to the press. So, prosecutor, you can argue about those things as evidence of consciousness of guilt. So, Gary, how would that work if we play that out?
Well, in terms of, okay, so we have a shooting, and now we're trying to figure out what the exposure is for Tex McIver. So now what they're doing is they're saying, okay, what did he do after the fact? So, for example, you know, you accidentally shoot your wife, but then you throw the gun in the river, okay? And so throwing the gun in the river is critical because that shows that you're trying to hide evidence. So your argument later that it's an accident seems a bit suspicious. So under that theory, any behavior he does after the shooting that can make him, you know, put him in a negative light, the state's going to have to seize on, because the bottom line is, you know, this case does have the problem of it looking like an accidental shooting. So, you know, taking what appears, at least at first blush, to be an accidental shooting and then trying to warp it into an intentional act where, you know, Tex is trying now to kill his wife in the backseat of the car with the hairdresser, best friend of his wife, driving the car at some ungodly hour after spending the weekend on the ranch. I mean, if you buy all that, then you seize on any kind of strange behavior that Tex might engage in after the fact. And yeah, the judge says, look, I'm not happy with this behavior. It seems a little strange, but again, does it move the ball forward in terms of charging witness intimidation? It does for the state from the point of saying, look, we have these additional criminal acts that he engaged in, those criminal acts which you can find him guilty of and he can be convicted and punished for, just goes to show his culpability for committing this act in the car while he's in the back seat.
We've got a lot more to talk about with this case, Gary, but I want to dial back to a witness who was on the stand for the second time in this case today. This is Blair Brown. She was one of the nurses in the ER when Diane McIver, the victim, was wheeled in after being driven up by Danny Joe Carter not terribly long after the shots were fired. Now, you remember Blair Brown was on the witness stand for the prosecution's case. The defense called her back on the stand for the defense's case. So let's listen to some of this. So, testimony from Blair Brown, one of the ER nurses. Gary, this witness was called back to try to contradict something that an other witness said also earlier in the case. I think you remember there were a flurry of nurses who testified, and one of them said that she thought she heard Tex McIver say the gun went off in the bathroom. And that nurse said that she thought she heard it from a distance, and there were all these other nurses around wheeling her in. Well, this is the nurse who thought that she heard the comment. Okay, so you got all these nurses, and the nurse who thought she heard the comment didn't know the nurses who were closer to McIver. Well, this is one of the nurses who was closer to McIver, and she says that she didn't hear the comment. So this is just deflating that McIver was spinning the so-called 6 different versions of this story that the prosecution promised us in opening statements that it was going to attack him for. Well,
okay, so Blair Brown is brought back. It's a calculated move by the defense for 2 purposes. The one you just mentioned, which is to contradict what somebody might have overheard. But in cross-examination, that witness said, I might have overheard it. I'm not sure. I mean, this is something you hear in passing. So that's not the real reason for bringing Brown back. Part of the reason why you want to bring Brown back is because you want to also show sort of a beauty contest. Look how many witnesses I have. So the prosecution has their list of witnesses. Now the defense needs to come up with their list of witnesses. So they want to put as many people on as possible, even if it really doesn't move the ball. It just goes to show the jury that, hey, I've got defense witnesses. Look at all these people that are coming forward. So in a way, by having more people there, it's kind of a beauty contest. And the other thing it shows is we're not afraid of Blair Brown. We'll bring her back. She's our witness. She was our witness. She was always going to be our witness. It's just that we have to go second. But see, we're bringing her on, and we're going to put her on. In cross-examination, you can get more out of a witness than you can in direct. And so in that regard, there's a little risk when you bring a witness back because the prosecution now can directly question the witness and ask leading questions that they wouldn't be able to ask in their case in chief. So you take a risk when you bring a witness back because now it gives the state a second shot to directly ask questions and lead the witness. But in terms of putting forth the argument, hey, I've got all these defense witnesses, it's a smart. In this particular case, it was a smart play on the part of the defense.
Yeah, Gary, they've just started asking questions from the jurors of this sleep expert who's been on the stand, so let's go back to court live. We have reached the end of the day in the Tex McIver courtroom in Atlanta, Georgia. Gary Gerstenfeld is an attorney. He's joining us here on Law and Crime to break down a little bit of what we've heard today. Gary, this is back in the estate planning and probate court world yet again in this case. We heard a lot of this in the state's case in chief. Now the defense has the case. They're turning around saying, hey, look, bottom line, the reason Tex McIver was selling off his wife's belongings is because her estate had to pay off some pretty serious claims. It had a $975,000 claim related to some business affairs that had been assessed against the estate. There were bequests made in the will that there wasn't enough cash to service. So this lawyer is saying, look, I'm the one that told him he had to start selling her stuff. He wasn't selling it because he didn't care about his wife. And we've been waiting for testimony like this.
Yeah, it's very powerful stuff, and it really does tear into the prosecution's theory that this was an intentional act and this is a cold and calculated individual. Life goes on, people die, assets have to be sold, estates have to be wound up. This is the normal kind of thing that happens in any situation where somebody passes on. Parents die and you have to move things around and sell assets and things like that. In fact, by having this attorney who is pretty he typifies sort of what a polished estates and trust lawyer would look like. He's sort of right from central casting to play that role. And he comes in and he explains exactly why, Tex is doing what he's doing. And it makes perfect sense. And this was a good play for the defense. This was a very good witness. This plus the expert witness they had on the sleep issues and things like that. Today was a good day for the defense.
So I think that the judge might still be in session. A lot of times there are things that they have to wrap up with the attorneys after the jury leaves. So I'm waiting to get a sense of where they're going. Let's listen back into that really quickly. More scheduling situations. So, Gary, look, bottom line, we had this important testimony. I just wanted to wrap up our point about this. This is deflating the state's motive. And what strikes me as bizarre about this is that the state under Georgia law doesn't need to prove motive. So the state has to prove intent. In other words, that he meant to kill someone by firing the bullet. And I realize that that's tightly wound with the nature of what motive is, but they don't really need to prove motive. So why are they proving motive if all of this other evidence is out there that can basically say that there was no motive? Like, why present it if you're going to get hit with such refutable evidence that that motive may not be correct or that it can't be proven beyond a reasonable doubt?
Well, again, everybody has their own optics when they're looking at the aftermath of a shooting and trying to figure out, is this a cold and calculated heart on the part of Mr. McIver, or is this an old guy who's ranting and raving in the backseat of a car about the neighborhood and where he is and is pulling out his gun to protect the family and shoots the gun inadvertently and kills his wife? I think the evidence probably points stronger to that. So what you have, at least looking at the case, I think, from all sides, is it looks like fairly an accidental shooting. Arguably, why this guy has a gun, perhaps is a different issue about gun control, and certainly beyond the scope of this case, or this discussion. But
let's not open that can of worms. Look, I mean, he legally possessed it, and it's just a question of how it went off. Was it intentional or was it accidental?
Right. And so what the government's trying to do is, motive is never an element of the crime. Motive explains people's behavior, which then can help establish whether there is an element necessary of intent to shoot and intent to harm his wife. And so if you look at, again, the example I used earlier, if you take the gun and you throw it in the river, objectively that looks pretty bad. If you're selling off now your dead wife's assets, arguably that could look really bad, except then you bring in the stuffy, lawyer who says, you got to sell off the assets to pay off the amounts to settle the estate. And now it starts looking like, well, okay, I'm just doing what my lawyer told me to do. And now that explains the behavior, and now suddenly the motive, as you point out, becomes far more deflated. And now what you're looking at is the normal things that people do when you wind up the estate of somebody who's passed away. Arguably, in this case, passed away from a shooting, which itself is unfortunate and sad. But for the state, they're left now trying to say, well, it was still intentional. You intentionally sold off her assets. You're a bad person. How that plays out with the jury,
Look, I think that this guy is credible. He's the attorney, and he said, look, he had to do this as the executor because that's what the law required him to do. He had to pay it off. So, look, Gary Gerstenfeld, we appreciate you sticking around about 10 minutes late for us here. You have clients to take care of, so we will carry this on next time. Attorney Gary Gerstenfeld here on Law and Crime.
Take care. It was a pleasure.
All right. We're going to wrap up the broadcast today here, folks. If you want to listen to some of the continuing scheduling discussions going on in that courtroom in Atlanta, just remember, you can go to lawandcrime.com. You can always click on the live tab. You can always there see the raw feeds as they come into us. It looks like, as I spoke, that feed wrapped up, though. I don't think you missed anything big. We will see you tomorrow starting at 9 a.m. here on the Law and Crime Network. A reminder that we are always on the air from at least 9 until at least 5 Eastern Time with live coverage of trials. For now, this is Aaron Keller. For everybody here at Law and Crime, have a good evening.